All right, good morning. In the 89th District Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And first up this morning, we're going to call People versus Preston Dunn. It is file 24-098FY. Counsel, you want to state your appearances, please?
Anthony Juliet on behalf of the people.
Lyle Peck on behalf of Preston Dunn, who's sitting to the left.
Okay, good morning, and we're here for a show cause and a preliminary examination. Where are we at on the preliminary examination, counsel? How are we proceeding today?
I believe we're going to run the prelim.
Okay, any opening remarks?
No.
Any opening remarks from the defense?
Not this time. The show cause will all be dependent upon whether or not this was a proper arrest.
Okay, first witness.
Deputy Slotsky.
Hand for me, sir. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can see. Go ahead.
Thank you. Deputy, where do you work?
Wayne County Sheriff's Department,
How long have you worked there?
2.5 years.
What's your title there?
Road Patrol Deputy.
Were you working there on October 17th of 2023?
Yes, I was.
Can you accurately recall your shift that day?
Yes.
Are you familiar with the defendant in this case, Preston Dunn?
Yes.
Is he present in the courtroom?
Yes.
What color shirt is he wearing?
We'll acknowledge Preston Dunn sitting right here to the left of me.
What's that? Oh, okay. All right. Go ahead.
Thank you. Did you have contact with him on October 17th of 2023?
Yes.
Can you briefly describe what led up to your contact with him?
I was sitting running stationary patrol at an intersection, and he was a passenger in a vehicle that was stopped for stopping in the intersection and not using a blinker.
And where was this at?
Webb Road and Apton Road.
In Sheboygan County?
Yes.
Okay. Did you make the traffic stop on the vehicle?
Yes.
And can you say again what the reason for the traffic stop was?
The vehicle stopped completely in the intersection and failed to use a blinker turn signal.
Okay. So did you end up making a traffic stop?
Yes.
Okay. What did you do after you made the stop?
Made contact with the driver and made contact through the driver's window with Preston Dunn.
Where was the defendant seated in the vehicle?
Front passenger seat.
So what happened after you made contact with the defendant?
So during a contact with the driver, observed Preston to be very fidgety, animated, talking fast, appeared extremely nervous. He was fumbling through the glove box when he was trying to help his mom, who was the driver, find documents that were requested by me.
At some point, did you request the parties to get out of the vehicle?
Yes.
And did you do any sort of Terry pat down of the driver or the defendant here?
Partially, I asked for consent. He agreed to that as well. Just wanted to make sure he didn't have any weapons on him. He said that was fine. And then I felt something in his front right pocket and asked him what it is. And he began to dig for it and then eventually fell out on the ground.
Okay. So you didn't take it out of his pocket or anything?
No, he didn't.
Okay. And did you inspect what this was?
Yes, I did.
What was it?
It was a small glass tincture or glass container, which had white crystal residue in it. From my experience and training, appeared to be methamphetamine.
Did you true narc or field test the substance?
Mr. Dunn was detained originally right then and there, and then it was read Miranda, and we talked to him about what fell out on the ground and what it was, and he stated it was meth, but we did eventually, when we got back to the department, true narc it.
What was the true narc result?
Positive for meth.
And when you confronted him about the methamphetamine, you said he acknowledged it?
Yeah, he stated that it was meth that he had used earlier that day. He stated that he didn't have a problem with it, that he was just using it on and off as recreational.
I have no other questions.
Russ, exam?
Officer, you were on traffic patrol, correct?
Regular patrol. I don't have a assigned traffic patrol, it's just a patrol that we do.
Were you stationary in your car alongside the road?
Yes, in a parking lot of a fire department.
Did you have a partner at that time?
I did.
And who was that partner?
Deputy Dutchkowski.
And you identified a vehicle that went past the stop sign and then stopped in the intersection?
Yes,
And what time of day was this?
I was in the evening, it was getting dark during the traffic stop. I'd have to refer to my report for an exact time if you'd like.
I'm looking at your report, and if you said on October 7th, 2023 at 22:19, would that be about right?
Yeah.
Now, 22:19 is military time. That would be about 10:19 for everybody else, wouldn't it?
Yeah,
It'd definitely be dark out, wouldn't it?
at the end of summer, yeah, getting dark.
That's in October,
And-
October 17th, 23.
Okay, yeah.
So that's not summertime, that's fall.
Fall, correct.
You indicated that the driver of the vehicle did not use her left turn signal.
Correct.
Was there anybody at that time of night behind her to observe it?
No, I don't believe so.
Do you have to use a turn signal if there's nobody behind you?
Yes, I believe you do.
So if there's nobody on the road, you still use your turn signal.
Yes,
It's clear that Mr. Dunn was not the driver of the vehicle. Is that correct?
yes,
He was a passenger.
yes.
At the time that you stopped the vehicle and you identified the driver and the passenger, did you have reasonable suspicion to believe that Mr. Dunn was engaged in criminal activity?
He was acting very nervous and fidgety. During that time, we also had verified that the vehicle did not have insurance and instructed the driver we'd be towing the vehicle.
Let me stop you right there, because in your report, you said that he appeared nervous and fidgety to you.
Correct.
And that's your subjective viewpoint, observing him in that car in that evening. Is that correct?
That's what I observed of him, yes. I've had contact with him before where he did not appear like that, so it was different to me.
Is acting fidgety and nervous, is that grounds to be arrested?
No,
So is it true that at the time you stopped the vehicle, you didn't have any grounds to believe that Mr. Dunn was engaged in criminal activity? Is that true?
originally I did not, correct.
Did you determine, did you stay on the record that you had called the State Farm office and had found out that there was no insurance on the vehicle?
We verified through the 1-800 number, correct?
At 10:20 at night?
Yes,
And this was not the driver's vehicle, correct?
Correct.
And I think you did say in your report that Mr. Dunn was helping to look in the glove compartment box for papers to show that it was insured or registration papers or something to that effect.
Correct.
So he was assisting you in trying to locate documentation for the vehicle, correct?
He was assisting the driver.
Assisting the driver, correct? Did Mr. Preston Dunn violate any traffic law?
He was a passenger in the vehicle.
So the answer is no.
Yeah.
Is that correct?
Correct.
And at the time of the stopping of this vehicle, the only thing that you observed was that he was nervous and fidgety and talking fast.
Correct. Rocking back and forth in the passenger seat, which was different than I've observed him before.
That's not criminal though, is it?
No.
At what point did you, as the officer, tell Mr. Preston Dunn to get out of the vehicle?
During the traffic stop was right after we advised the driver the vehicle was going to be towed for no insurance. They were both going to have to exit the vehicle.
Okay, so you advised both the driver and Mr. Dunn that this vehicle was going to be towed out of there. They would have no way to walk home or go where they're going. And they were stuck at that time, right?
Well, I advised them to try to contact a ride. If not, we try to ask the tow truck to give them a ride. And if that doesn't work, then we offer a ride ourselves. So they would not be stranded.
Now, my understanding is you're going to tow the vehicle because there was no insurance.
Correct.
Were you familiar with Michigan Vehicle Code 257.328 regarding no insurance? That's a civil infraction?
That's not true. No security, 500.1032 or
One oh
something.
two.
Well, yeah, is a one-year misdemeanor. And how's that relevant to this charge?
They had provided no insurance is what the
No
chart.
proof of insurance.
No
is a
proof
civil
of
infraction.
insurance.
Not having insurance, driving an uninsured vehicle is a
Correct.
one-year misdemeanor crime.
Correct.
All right.
Not showing, they couldn't show you a proof of insurance, could they?
Correct. And it was verified through State Farm and the VIN that the vehicle did not have insurance.
How did you identify that it did not have insurance just through State Farm? How do you know it wasn't some other insurance company that had insurance?
They had a policy that said it was an expired policy, I believe. And we called that company and it did not have
I see,
insurance.
I see. Did you ever find insurance on that at some point down the future or not?
No, they
Or
never,
was that the
they never
conclusion?
provided it. It's not my responsibility to follow up and find insurance. for that
Okay.
vehicle.
As a passenger, Mr. Preston Dunn wasn't required to have proof of insurance, was
Mayor,
it?
I guess I'm gonna object to the relevance on this insurance.
Yeah, I don't know why that's relevant. I mean, he wasn't arrested for no insurance. I mean,
Okay,
right, he's a passenger. We all get that.
Okay.
He's a passenger. He's not responsible for the traffic violation that resulted in the stop. He's not responsible for whether there's insurance or not. He's not responsible for the car being seized or towed. I get all that.
okay.
So assume that's all true. Continue.
Sir, officer, at what, you had asked him to get out of the vehicle
Correct.
and then you commenced a pat-down search to make sure there was no weapons or anything?
I engaged in a conversation with him first.
And what was your conversation?
asking about his actions inside the vehicle, why he was rocking back and forth, why he appeared different than other contacts we've had with him, why he was sped up, why he appeared to be sweating and nervous at that point.
And was there a statement made by Preston?
There's many statements made by him. We had a conversation on the side of the road. I asked him if he had anything illegal on him or if any weapons on him, if he'd mind if I pat him down. He said he did not mind, put his hands up. I pat him down. I felt the small thing in his pocket. I asked him what it was. He said, I'll get it. Started digging for it. It fell on the ground and it was a small glass container with white crystal substance.
So he had his hands up.
Yep.
And then you commenced your search.
A pat down, yeah.
Pat
His
down.
waistband, my finger felt something and I asked him about
And
it.
that's when something fell out of his coat or pocket, and that's when you arrested him.
I felt it. I asked him what it was. He began digging for it. It fell out on the ground.
So the only reason to further question the passenger is because he was nervous and fidgety and talking fast.
Yeah, I was inquiring why he was different than other contacts I've had with him.
There's no other particular reasons other than his behavior that prompted you to do the search.
I'm on the side of the road with him and I wanted to make sure he didn't have any weapons on him as we're talking.
Okay. Nothing further.
Any redirect?
No,
Or you can step down, officer. Thanks.
no, Your Honor.
Any proof from the defense?
No.
Just briefly, Your Honor, on October 17th of this year, Deputy Pulaski testified that he conducted a traffic stop on a vehicle for going into the lane, into an intersection past the stop sign and failing to use the turn signal. After he made the traffic stop, it was further verified there was no insurance on the vehicle. He ordered the driver and passenger out of the vehicle. He did a pat down on the defendant when he was out of the vehicle. He appeared fidgety, nervous. So the deputy was within his rights to do a pat down. He was within his rights to order the defendant out of the vehicle. Upon doing the pat down, he felt something in the defendant's pocket. The defendant grabbed it. It fell out. It appeared to be methamphetamine. It was subsequently tested positive for methamphetamine, and the defendant admitted it was methamphetamine and admitted using it earlier that day. I'd ask court to bind over.
So you're seeking a bind over only on count one then?
Yes.
All right, Mr. Peck, go ahead.
In reviewing whether probable cause existed to make this arrest, you look at the totality of the circumstances, but a police officer's subjective characterization of the events is not controlling, and that's Norwegian 305 Mishap 758. You cannot use the subjective officer's comments because he was nervous and fidgety to then ask him to get out of his car, pat him down, and then arrest him if the substance came down.
You're treating this analysis as if just because he sees the passenger fidgety, he's arrested, but that's not what happened. You'd agree, would you agree that the case law supports that officers may routinely order occupants out of vehicles during a traffic stop for officer safety? They can order them in a car if they're out of it. They can order them out of a car if they're in it. That's been the law for decades. That's not an arrest to order somebody out of a car. That's an officer maintaining control at a traffic stop. So when did the arrest happen? that you're saying was
The
illegal?
arrest occurred when he asked him to get out of his car, and he had his hands up, as he indicated,
Make your record.
and is his arrest right there. And he had no other grounds to arrest a passenger from a vehicle that had no criminal activity, reasonable suspicion at the time of stopping the vehicle. Just doesn't exist here.
All right, thank you. I'm going to bind over Mr. Dunn on count one. There's probable cause to believe that he did possess the controlled substance methamphetamine. A small glass vial on his person fell out of his pocket when he's attempting to retrieve it. The officer sees what it is that is suspected. Methamphetamine, asks the defendant admits it's methamphetamine. A true narc search confirms or indicates that it is. That's probable cause to bind over on the possession charge. Count two will not be bound over. There's been no proofs submitted on the possession of cocaine. The defense argues that this was a result of an illegal arrest. I think that's a fundamental misunderstanding of the law and the facts of what happened. There's nothing unusual that happened here whatsoever. During a traffic stop, the officer, as he is allowed to do every day and twice on Sunday, orders occupants out of a vehicle for officer safety. The officer engages in a conversation with somebody who's appearing nervous. Nothing unusual there. The officer says, "Hey, I want to make sure you don't have any weapons on you. Do you mind if I pat you down?" The suspect says, "No." So it's a consent pat down. Again, nothing unusual. The officer feels something. It's not plainly a weapon, so he doesn't go fishing in the pocket. That would have been illegal. But he just asked the guy, "Hey, what's that thing?" I felt. And as Mr. Dunn is fishing for it, it falls out. Now it's in plain view. And then he talks to him and he admits what it was, and it tests positive. There's absolutely nothing unusual or improper here. So the argument that there was somehow some illegal arrest is meritless. In fact, Mr. Dunn wasn't even arrested until he confirmed that he had been. All right, so there's the bind over. We also have a show cause. Mr. Dunn, it's alleged that you're in contempt of court for violating your bond by consuming alcohol. Actually, there's two of them. One's for you to not appear until April 4th, but why don't we just arraign them on that now since we're all here. It's alleged that you've tested positive twice for alcohol, once on February 26th and once on March 1st. If you're found to be in contempt, you can be jailed up to 93 days or fined up to $7,500 or both. You have the right to have a hearing where that would need to be proven, and the right to the assistance of your attorney at that hearing. Separately, if I believe that you're violating the conditions of your bond, I can revoke that bond. So Mr. Peck, with Mr. Dunn being advised of his rights and penalties, do you know how he wishes to proceed on the show cause?
I haven't talked to Mr. Dunn on the show cause, but he's completely not guilty at this time.
All right, so what we'll do is we'll enter a plea of not guilty. We'll set this for a circuit court arraignment on April 9th at 1 p.m. I guess for judicial economy purposes, the contempt hearing would be typically scheduled in the district court since the alleged bond violations occurred while it was down here. If the parties consent, I can send the contempt violation up to follow it on the circuit court track, just so we keep the case in one forum instead of two. Does that make sense, Mr. Peck? Do you want to do that or no?
Whatever's convenient here, I guess, is the best way to do it.
I think that makes sense.
Okay, so we're going to send up to the circuit court the contempt citation as well, and that'll be scheduled for a hearing on the April 9th at 1 p.m. as well. I guess, Mr. Juliet and Mr. Peck, I'd want to hear from you both as to continuation of bond now that I've got two positive alcohol tests for Mr. Dunn.
Your Honor,
We'll have a hearing on the contempt, but as a condition of bond, where are we at?
Your Honor, I'd ask the bond be revoked. I mean, there's two positive alcohol tests on a possession of methamphetamine charge. I mean, I know I got to present proofs at a hearing, but I've got lab results here confirming by way of affidavit that there's been alcohol detected in his system, so I'd ask the bond be revoked.
Mr. Peck? Mr. Peck?
Preston Dunn is showing up today, and I expect him to show up for all court hearings in the future. And until we have an actual evidence on violating with an alcohol bond or touch, I think it's preliminary to revoke his bond at this point in time. It's not that he's not showing up to court and not showing.
I'm going to revoke Mr. Dunn's bond. He'll be remanded to the sheriff until further order of court. I'm not concerned about him not showing up. I am concerned about him continuing to drink. I've got 2 lab tests in the file that show that he's violating conditions of bond. Morning, Mr. Burgo.
Morning, Your Honor.
All right, what do you want to call?
Your Honor, Mr. Carney has a few items that I believe
Sure.
he can dispose of.
All right, so we've got people be Jonathan Carney. We've got 3 files. Let's first do the arraignment on the so this is file 24-0175. And this is an arraignment on a larceny by conversion with a habitual offender notice. Have you had a chance to review it, Mr. Carney?
I have not, other than in detail, Your Honor, but we were able to review it briefly yesterday. Mr. Carney would plead not guilty on that.
Okay, do you wish to have its allegations formally read?
No, we would waive the reading, Your Honor.
All right. So, Mr. Carney, I won't read the allegations, but I'll just advise you, you're charged in that case with larceny by conversion over $1,000 with a habitual 4th notice. That makes it a felony punishable by up to life in prison and or a $10,000 fine or up to 3 times the value of the property involved, whichever is greater. You have the right to counsel and the right to a preliminary examination within 21 days. And do you know, is he seeking counsel then in this matter?
Yes, Your Honor.
So we'll refer it to the Office of Assigned Counsel for appointment of Mr. Wergo. And we'll schedule it for a probable cause conference. Well, right now, I think with some scheduling wrinkles, the PCC is being set a day before the prelim. I know that's not super helpful for the people in terms of subpoenas. But we'll schedule it for a probable cause conference April 4th at 10:30 a.m. and a preliminary examination April 5th at 10:30 a.m. As to bond on that file, Mr. Wergo?
Your Honor, Mr. Carney has always shown up for every single court date. The court is aware there are other pending matters. Failure to show has never been an issue with him. Your Honor, I would request that he have a personal recognizance bond. He intends to deal with this. We would also ask that the court not have any no contact orders. It's my understanding that the parties are still working together to resolve this issue together. And it's my understanding that in speaking with Mr. Carney that, and I have not had a chance to speak with Ms. Miller on this yet, but the prosecution is also aware of that.
All right, Ms. Miller.
Your Honor, I would note that Mr. Carney has 2 other open files at this point. I would acknowledge that this new offense has a date of offense of 2023, so it didn't occur when he was on bond for the other files. I guess I haven't had a conversation with Mr. Wergo about the victims. I can confirm that with others. I'm not sure who that conversation was with, and I don't have a note in the file. I don't know if just as a initial matter, we can do the no contact, and then I can just confirm with whoever spoke to the victims, and we can, do a stip today if I can confirm that they want contact to continue.
All right, well, so I'll set it at a $5,000 personal recognizance bond with the standard conditions that you have to show for court. Can't leave the state without permission. Let us know if you change your address or phone number. You can't break the laws of the state of Michigan, bring political subdivision thereof. The only special condition I will place is no contact with the complaining witnesses in this matter. But then, Mr. Wargo, if you confirm that with the prosecutor's office, we can submit a step from that. They'll take care of that file. We also then are scheduled for a preliminary examination in the 114 file, where we have.
Your Honor, we would be waiving.
Do you have the waiver paperwork? Or do you need to
Your Honor, we would have to do it on the record. My apologies.
No problem. All right, Mr. Kearney, you understand you have the right to a preliminary examination where the prosecutor would have to prove by a probable cause standards that you committed the offense, and you have the right to the assistance of an attorney at that hearing. Understand?
I do.
Has anybody promised you anything in exchange for the for waiving that hearing?
No.
Has anybody threatened you to make you do so? Is that your own free choice? Okay, you want to go ahead and do that. All right, thank you, Mr. Kearney, and the counsel and prosecutor consenting to the waiver of the preliminary examination. I'm going to find that waiver is knowingly, voluntarily, and understanding made. And so I'll bind over Mr. Kearney for arraignment on the charges in the complaint. Circuit court arraignment date will be April 9th at 10 a.m. And bond will be continued in that matter. All right, and then our third file with Mr. Kearney is file 23-724 SD for sentencing and the contempt hearing. And are we able to have any witnesses on the contempt hearing or no?
No, Your Honor, the doctor was not available on the short notice.
Okay, well, we can just continue that. We can go forward with the sentencing. Mr. Virgo, have you had a chance to review the report and recommendations with your client?
Yes, we have.
Any actual additions or corrections to the present?
None, Your Honor.
Are there any factual additions or corrections?
No, Your Honor.
Any elocution on behalf of your client?
Your Honor, nothing that the court isn't already aware of. We would ask that the court follow the recommendations.
All right, Mr. Kearney, it's not required that you would say anything, but it is allowed. Is there anything you want to say?
Yeah, I know I was wrong for being under the influence of my own medication guide, and I knew I wasn't totally awake, honestly. I just made a huge mistake, and I gotta own up to that, so.
Thank you, Ms. Miller. People's recommendations.
Thank you, Your Honor. Mr. Kearney is 40 years old. He does have a criminal history going back to 2003 that does include prior convictions relating to controlled substances. I see one in 2003, 2004, 2014, as well as other other convictions. On the date of the offense, Mr. Carney was driving at varying speeds. He was going back and forth in his lane, and he was hitting the rumble strips on the side of the road. When he had contact with law enforcement, he did admit to law enforcement that he had recently used methamphetamine. The lab showed in his blood gabapentin, amphetamine, buprenorphine, methamphetamine, and prazolam. So it's definitely concerning that there was so many different substances in his system at the time. I'd ask the court to order the reimbursement for OWI to the sheriff's department for $225. And I do see the recommendation for 30 days in jail. I think due to the number of substances that Mr. Carney was on, that some amount of jail maybe isn't appropriate. And due to his history of having controlled substance convictions in the past. Thank you.
All right, thank you, Mr. Carney. If you please stand for the court sentence. Well, I mean, this is not a great situation, Mr. Carney. You know, you do have a pretty significant criminal history involving controlled substances. Here you were admittedly abusing your prescribed substances. And there's evidence found in the car of that, you know, these so-called tutors. So it appeared that you were snorting some of your prescribed medications. There's a lot that's on board here. Not just that, but then I understand, given some of the pending charges you have, that you're not down here today admitting to using methamphetamine. But I'm looking at a lab report that shows it, and I'm looking at a police report that says you admitted using it. So you're using meth and abusing your prescriptions. You've got poly substance abuse going on, lots of drugs on board, and you're out there driving and you're drowsy. You're causing a danger to yourself and many other people. And with your history, you know far better than that. I can also take judicial notice of the fact that I had a whole lot of hearings with you over this period of time when people were expressing concerns that you were abusing your prescribed substances and wanted you to get help. And you just kept telling us, no, that wasn't happening. All anybody wanted for you was to get the help and correct. And you continued to refuse that help, really. That's too bad. I mean, I think all anybody wants still now is for you to get things right. In any event, there's some fines and costs. There's $225 for the OWI reimbursement, $200 in court costs, $50 fee to the state, $75 in crime victims fund, and $175 penal fine for $725 total. And I guess given the length of, given the significant criminal history, the significant poly substance abuse, and the danger to the public here, there is grounds to depart from the presumption of no jail, no probation. And I'm going to order Mr. Carney serve 60 days in the Sheboygan County Jail with credit for 1 day release to serve. I think in the interest of judicial economy, the contempt for the one test that we do have is just not going to serve anything. So we'll just dismiss that contempt. That'll be the judgment of the court. And if you wanted to appeal, you'd have to file an application to the circuit court within 21 days. If you wanted a lawyer, you'd have to ask within 14. Okay, let's call people be Brian and Hilla. 23-897 FY. Mr. Gilbert.
Good morning, Your Honor.
What are we doing on Mr. Hill?
Mr. Hillo was planning on running his preliminary exam. However, Your Honor, we discussed it, and I've also discussed with the prosecutor. He will be waiving the preliminary exam. And also, if it pleases the court, we would ask the court to possibly consider a bond reinstatement or a PR bond.
Okay, do you have the waiver form or do you want to grab it?
If I could get it from you, Your Honor.
All right, Mr. Hilla, you understand you have the right to a preliminary examination where the prosecutor would have to present a probable cause that you committed the offense in the complaint and the right to the assistance of your attorney at that hearing? Has anybody promised you anything in exchange for your waiver? Has anybody threatened you to make you waive? Is that your own free choice to do so? Or if you want to review and sign the written waiver, then
Okay. Can we approach, Your Honor?
yes. All right, and Mr. I'm going to find that the waivers knowingly, voluntarily, and understandingly made. And, therefore, I'll find over Mr. Hilla for arraignment in the circuit court on the charges contained in the complaint. Circuit court arraignment date will be April 9 at 2 p.m. And as to bond, Mr. Gilbert?
Oh, Your Honor, I have discussed this with the prosecutor, and we'd ask that the court possibly consider reinstating the bond or reinstating a PR bond. Mr. Hillo's bond had gotten revoked because he had contact with the alleged victim. This is a situation in which there's a mental component to it. I think Mr. Hill and I've had a good conversation that he cannot go help do anything at that residence. So the prosecutor and I have agreed that there should be no contact between him and the alleged victim. He cannot return to his residence and has to stay on his medication.
All right, Ms. Miller?
That's correct. I did speak with Mr. Gilbert about, I don't have an objection to bond being reinstated with those conditions in place.
All right, well, Mr. Hillo, based on that, we'll reinstate your bond on the same conditions that were previously assessed. See you April 9th at 2 p.m. Mr. Gilbert, you have another one ready to go?
I do, Your Honor. Deanna Wilquang.
This is file 088 FY.
There was two files, Your Honor.
One of them, I got a Nally.
Excellent. And then the remaining one, Your Honor, is here for a preliminary exam. Mr. Wilfong will be waiving that arraignment. I mean, waiving that agreement. She also has a show cause, Your Honor, for dilute tests, which she wishes to plead guilty to.
All right. Ms. Wilfong, do you understand you have the right to a preliminary hearing where the prosecution would have to prove by probable cause that you committed the offense in the complaint and the right to the assistance of your attorney at that hearing? And has anybody promised you anything in exchange for waiving that? They threatened you, maybe? No. Is that your own free choice?
Yeah.
Understand you've got the right to have a hearing on whether the violated bond and are in contempt of court for a dilute test.
Yeah.
If you are found to be in contempt, you can be jailed up to 93 days. You're fined up to $7,500 or both. Do you understand that?
Yeah.
Knowing all this, how do you wish to plead to contempt, guilty or not guilty?
Guilty.
I'm sorry.
Guilty.
Okay, so as part of your bond conditions, you're required to submit to and pass urine drug and alcohol tests. Is that correct?
Mm-hmm.
And did you submit a dilute specimen on February 22nd.
Apparently I did.
Okay, you don't contest that it was diluted or demand a hearing in that?
No.
All right, you satisfied with the factual basis, Mr. Gilbert?
I am, Your Honor. Thank you.
Yes.
All right, I'm gonna find that the plea to contempt is knowingly, voluntarily, and understandingly made, and that there's a sufficient basis in fact and law to find for contempt, so we'll do so.
I'm just.
All right, so I'm gonna find that the waiver of the preliminary examination is knowingly, voluntarily, and understandingly made. I'll bind over Ms. Vaughn for arraignment in the circuit court on the charges contained in the complaint. Arraignment will be April 9th at 2 p.m. As to sanction on the contempt, Ms. Goodrich.
Your Honor, I think a short term of incarceration may be appropriate. This was a violation of the bond conditions on a methamphetamine case. It looks like her 2 prior felonies, although older, also dealt with controlled substances. So that's an issue of concern.
All right, Mr. Gilbert, so as to sanction.
Your Honor, this was a dilute test, and I would ask that the court not impose any type of incarceration. I was going to ask if the court, because I know she has a pretty good job that she's going to be starting next week down in Ithaca, if she could do some community service. I don't believe that when asking and talking with her, I don't believe that this was an attempt to deceive the court, and she's making corrections so this does not happen again.
All right, well, I'll continue the bond and we'll issue a judgment of contempt for the dilute test. And I'll order Ms. Wilfong to complete 8 hours of community service with proof to the district court within 30 days. But Ms. Wilfong, you should understand, further, now you're bound over to the circuit court, any further bond violations, the prosecutor can show causes or can even seek a warrant if there's violations. All right. So we'll see.
Thank you very much, Your Honor.
Thank you.
I'm not sure. For the rest of the preliminary exams, I have Lucinda Panicali, who I believe is going to waive the 21 days. She's looking to retain counsel, so we're asking for an adjournment on that one.
So would you be able to, want to bring her down or?
I talked to her about if I could have her sign something. She's ready to sign.
Okay, you can just have her sign the 21-day waiver.
I can do that.
Okay, any objection to an adjournment then?
No objection. I believe that the other 3 co-defendants have been adjourned.
Do you know what date?
I believe it's the 12th.
Well, let's schedule this then for a preliminary examination on April 12th at 10:30 a.m. And you can submit our 21-day waiver. Great.
I'll do that.
So we do not need Ms. Panicali.
Then my last prelim, Your Honor, and I don't know if the court is already aware of it, is Mr. Quick, and I believe that was getting adjourned.
Yes, I signed that.
Excellent.
I believe Mr. Gilbert also has Brent Perry. We have a status conference today. We haven't received any.
Oh, yes. Brent Perry is up for a status conference. We're just awaiting reports and we don't have them yet. Is that right?
That is correct.
All right, let's set it for a continued status conference on April 12th at 10:30 a.m.
Thank you very much.
Thank you.
Mr. Wirgo, we had William Thompson. I see that there was a stip coming, but I don't know if we ever got it. Do you know?
Your Honor, I did stop in over at the prosecution office and sign that stip. I did speak with Mr. Thompson today, and he gave me the authority to also sign the 21-day waiver on his behalf.
All right, so we have a stip moving the prelim into contempt.
Yes.
Okay, I'll sign that so we don't need Mr. Thompson. All right. And then we've got Mr. Moyer this morning. Do you know what we're doing on him?
I do believe that we are running that preliminary.
Okay. Do you have any waivers we can take care of now while we're bringing them down?
Your Honor, we do have Conrad Oakley that I believe is going to be adjourning today while we continue to discuss resolution. It may be a misdemeanor resolution, so it makes sense to keep it here.
So 24-002 FD, people be Conrad Oakley up for prelim. And there's a 21-day waiver that's already been submitted. Mr. Wargo, do you consent to an adjournment?
Yes, Your Honor.
All right, so we'll continue that preliminary examination to April 12th at 10:30. And we have Marissa Johnson, file 24-119 FY.
And that one we would be running as well, Your Honor. And then there was a Michelle Engel. It's my understanding, Your Honor, Miss Engel is in Emmett County, and we weren't able to secure her Zoom appearance today. We would ask to adjourn on that one.
Yeah, I think we have.
Okay. Apologies, Your Honor. It's not in front of me these days. The brain won't remember it.
You had people be, oh, William Thompson was 2 files. Okay, so that's all good. About people be Klein.
Proclaim, Your Honor?
Yes.
Yes, Ms. Klein here. We are ready to move forward on the sentencing.
Have you had a chance to review the pre-sentence report?
Yes, and Ms. Klein and I discussed that this morning as well.
Any additions, corrections?
None other than, Your Honor, I would like to make the court aware that Ms. Klein has a present medical issue with her feet that requires significant medication that does potentially pose a health hazard to the jail. If you can just give me 1 second to get. She has open sores on her feet, Your Honor. We would request that if the court is inclined to follow the recommendation for jail, that she be allowed to do a deferral for approximately 1 week for that matter to go ahead and alleviate.
Right, thank you. Any other allocution? Anything you want to say this time?
Yes, when I got out of jail, I had a really bad relapse. And I surrounded myself with a person, she was living with me. And it was bad, and I just went downhill. And I realized I have addiction to anymore, and I realized so I'm trying to work on that along with the drug addiction, and my feet, they're just open, the sores are open. I'm just scared. I know I have to take responsibility, and I'm scared to go in there and with MRSA, or my health is horrible because of the relapse. I'm an IV user, and I have health now issues. I have financial needs. So I have a letter.
You have a letter?
From the doctor, just.
If I may just review that really quick. Your Honor. And then if I may present this to your bailiff, Your Honor.
Ms. Miller, any recommendations from the people?
Yes, Your Honor. Ms. Klein is 46 years old. She does have a pretty significant criminal history. There was a retail fraud third attempt in 2022, as well as a number of insufficient funds checks back in 1996. No account check conviction in 2004, insufficient funds check 2007, conspiracy embezzlement conviction in 2007, again, a larceny from the building attempt in 2007, as well as some other controlled substance convictions. So there is a history of theft offenses and recent, as recent as 2022. The date of the offense in this case, she took energy drink, shampoo and conditioner, and various makeup items in the amount of $43.11 without paying for those. The goods were recovered, so there's not restitution owed. But I don't think that probation would serve any purpose in this case due to the fact that she was recently convicted of the same thing, and it didn't deter her conduct, given that and her extensive criminal history with similar types of offenses. I do think a jail sentence is appropriate.
Thank you. Well, Ms. Klein, there's some financial penalties associated with this: $50 fee to the state, $75 crime victims fund, $200 in court costs, and $200 penal fine for a total of $525. You do have a significant criminal history, not just involving controlled substance, but a number of property crimes, including a fairly recent shoplifting. You know, and I agree with what you said here today, that, you know, you do seem to have well, perhaps it is some compulsion, but you do have some significant track record of stealing items. Therefore, I think, given that, those are grounds to depart from the presumption of no jail or probation. I don't think probation is appropriate. I do think that some jail is appropriate. This is a maximum of a 6-month penalty. I'm going to order that you serve 120 days in the Sheboygan County Jail with credit for 18 days previously served. Jail is equipped to deal with the medical needs, perhaps with the report of this letter from the doctor to the jail administrator. All right, Ms. Klein, if you want to appeal, you have to file an appeal to the circuit court within 21 days, and if you wanted a lawyer, you'd have to ask for the report tonight. All right, so why don't we call Ms. Finch before we run prelim as well? Tashina Finch. Got, sentencing in file 7-1, and also a probation violation sentencing in 404. Right, and I guess in the probation matter, the objection, we just, for that one, just revoke her probation and indicate an unsuccessful discharge.
For the probation violation, that's fine.
Yeah.
Yeah.
So I'm not going to impose an incarceration component there, even though it was recommended in other cases, the real driver.
Understood, Your Honor.
So the probation matter will revoke probation, discharge unsuccessful. All right, so in the 428. (0071) SD. You had a chance to review the pre-sentence recommendation?
Yes, and Ms. Finch and I did discuss the matter.
All right. Let's see.
Your Honor, it's my understanding Ms. Finch is in agreement with the recommendation and is ready to take her medicine as it were.
All right, it did appear that way from the reading and the substance use assessment as well. Ms. Finch, is there anything you want to say today?
I just want to apologize to the court for being very wrong decision. I just want to get it over with and move about life in the right way.
Ms. Miller, any recommendations from the people?
Yes, Your Honor. Ms. Finch is 36 years old. She does have some criminal history, including a prior operating while intoxicated conviction in Presque Isle in 2020. She was on probation in this court when she received the current case of the operating while intoxicated second offense. She did have a blood alcohol content of a 0.118 and 0.117 when tested by the Intoxicalizer 9000. I would ask that the operating while intoxicated reimbursement be ordered to the sheriff's department in the amount of $150. I would ask the court to follow the sentence agreement and not sentence to more than the 93-day jail cap that was agreed to on the plea. There is also a vehicle forfeiture in this matter. I can continue forward on that if the court would like, or if the court wants to impose sentencing first, I'm not sure.
Is there any contesting to the forfeiture?
We did, there was no claim of an interested party filed. There was notice provided to,
So I guess similar to restitution, then, you know, if there's an objection, we have a hearing. Or are you asking for a hearing on the forfeiture request, Mr. Wickett?
It's Ms. Finch's understanding that the lien holder does have an interest in it, but credit acceptance, but Ms. Finch doesn't really have a dog in that fight.
Okay, and they haven't filed a claim.
no, and they were served.
Okay, I'll enter the forfeiture then.
Okay, and I do have an order indicating the forfeiture for the court.
All right, well, Ms. Finch, you know, I think you're here for sentencing. Fairly open-eyed about what was going on in your life and what brought you to today and what was going to happen today, and prepared yourself for that. So I will follow those recommendations. I see that you said that you were intending to participate in AA in the jail. I'm sure what you did.
Yes,
And that,
yes.
to get things turned around, it looked like you did have a period of some sobriety in the past. So I think we get back to that place, because now, as I'm sure Mr. Wergo advised you, for the rest of your life, another one is a felony. And it's a whole different ballgame. You know, all of your history so far is all district court matters. And there we measure things in terms of days and months. In the circuit court, we measure things in terms of years. So you don't want to end up there.
No, I'm gonna change my behavior now.
All right, so there is $50 fee to the state, 75 crime victims fund, 200 in court costs. But you know what? You owe a lot on a bunch of files. This is what I'm gonna do. You got a lot of holes to dig out of anyway, so we will try to not make this one deeper than it has to be. $50 fee to the state, $75 crime victims fund, $150 the OWI reimbursement. So that's a total of $275. I won't specify the court costs in this file. And you have signed the vehicle forfeiture also, and I'll order that you serve 93 days in the Sheboygan County Jail with credit for 5 days previously served. If you wanted to file an appeal, you'd have to file that to the circuit court within 21 days. And if you wanted a lawyer, you'd have to ask within 14. Good luck to you. Let's call up Mr. Bitterman, so we make sure to get that done since it's a sobriety court matter. So we do approve that. I do one more sentence. Seth Bitterman, file 0004. You want to say anything at that point?
We would ask that the court follow the recommendation. Seth is ready to do the program, and I believe that he's been demonstrating that.
All right, Mr. Bitterman, is there anything you want to tell me or no?
No.
Ms. Miller?
Thank you, Your Honor. Mr. Bitterman is 24 years old. He has a prior operating while intoxicated in 2022. Due to that, he was accepted into the sobriety court program in this court. I think that the program is a good program, and he should be accepted and sentenced into it and be ordered to pay the OWI reimbursement of $150 to the Sheriff's Department. But I hope that he makes the most of the sobriety court program. Thank you.
Thank you, Mr. Bitterman. Please stand for the court sentence. All right, you're sentencing on operating while intoxicated, second offense, license restriction violation, open intox. I'm going to assess the fines and costs as recommended in the pre-sentence report in full. So I won't run through all of those on the record right now, but that's a total of $895. I'm going to order that you be placed on probation for 2 years and entered into the 89th District Court Sobriety Court Program and comply with all its conditions. Serve 3 days jail and credit for 3 days previously served. Mr. Bitterman, but one thing I do want to tell you is it's clear to me from reading through all of this that the sobriety court program is going to, it's going to be a shock to you. Maybe you don't realize that right now, and maybe you won't understand what I'm telling you today, but time's going to come in the next few weeks or months where you're going to understand this. Because as of this date, you don't fully recognize the extent of your drinking problem. But you had a drunk driving in 2022. You got one now. The substance abuse assessment indicates moderate to severe drinking issues, and I don't think you recognize that. You do have some professional and personal interest as a hobby in some brewing type of things, and so this is going to be, you've got some difficult choices down the road because your professional or hobby interest in beer is, you know, fine for most folks, but you don't yet recognize today, for you, alcohol is not a good plan at all. And you're gonna either not succeed in the sobriety court program, or you're gonna have to come to terms with your relationship with alcohol. So I'm just giving you a fair warning, this program is not gonna be easy for you, and at some point you're gonna say, what have I done? But when that day comes, I'm telling you, you've done the right thing. So just press through. Good luck to you. We are entering a judgment, so if you want to appeal, you can file an application to the circuit court within 21 days. If you want to Oh, there's a mathematical error. I thought that was pretty low for sobriety court. Sorry, there was a mathematical error in the pre-sentence report. I think because it didn't include the oversight fees. So, so all of the individual assessments are correct. Just the totals were wrong. So the total is $2,095. All right. Good luck to you. All right, and then we can call Bobby Moyer.
Oh, deceased. Oh, yeah.
All right, so this is People v. Darren Moyer, file 23-0910FY for a preliminary examination. Mr. Juliet, any opening comments from the people?
No.
Mr. Virgo, any opening comments from the defense?
None, Your Honor.
Your first witness?
Corporal View.
Corporal View, if you want to come on up to the you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, go ahead, Mr. Drew.
Thank you. Corporal, can you state your full name and spell your last name?
Michael View. My last name is Vieau.
Thank you. Where do you work?
Sheboygan County Sheriff's in jail.
Okay, and how long have you worked there?
Just over 2 years, sir.
And were you working on December 11th of 2023?
Yes, I was.
Can you accurately recall your shift that day?
Yes, I can.
Okay. And are you familiar with the defendant in this case, Mr. Moyer?
I am, sir.
Did you have contact with him that day?
I did, sir.
Okay, can you just briefly describe for the court what that contact consisted of?
That day, the contact with Mr. Moyer was around our dinner pass for the offenders. Once dinner was passed, we do a med pass or medication for the offenders that take medications. Upon passing medications to Mr. Moyer, I attempted to hand him his medications. He did not have water. Offenders are instructed to have water to be able to take those medications, to verify medications are taken. Mr. Moyer didn't. I asked him to get water to be able to take his medications. He turned and then got irate, turned back around and said, "Give me my pills," used profanities. I said, "I'm not giving your medication without water." He then took the tray that he had in one hand, shoved it out at me. I then backed away from the tray chute. The tray kind of slid down my front, the food tray. To describe the doors have a tray slot where the food fits through in the jail. And I then turned around to go retrieve keys to remove the offender and place him in observation up front. Upon turning around, Mr. Moyer then took the remainder of the trays in that cell and threw them down the hallway at me, hitting me in the back. So after that, I then called for additional staff. In attempting to remove Mr. Moyer from the cell, Mr. Moyer then threw water at me and a couple other items, a cup, some dice. In throwing a cup at me, he was, when entering the cell, I told Mr. Moyer to turn around to be restrained. He refused, told me that he was going to hurt me. Told him to turn around to be restrained. He refused again. I drew my taser walking into the cell. Told Mr. Moyer to turn around and be restrained. He refused. That's when he threw the water at me. I gave him several more verbal directives to turn around to be restrained. He refused, and then he threw a cup at me. When he threw the cup at me, I did fire my taser and strike Mr. Moyer, and then restrained him, removed him from the cell, and placed him in observation up front, and medical and everything else ensued after that.
Okay, is the defendant present in the courtroom today?
Yes.
Can you describe what he's wearing?
He is wearing Sheboygan County Jail oranges.
Your Honor, can the record reflect the witnesses identified the defendant?
Yes.
And this happened in the Sheboygan County Jail?
It is.
Okay. I have no other questions.
Cross-exam.
Corporal Vio, you indicated that you were hit with a tray in the back of the hallway.
Yeah, yes, sir.
The way you described the opening of the slot, doesn't the slot then is it perpendicular to the hallway?
That's correct.
If you had gone, did you then testify that you had walked down the hallway?
I did, sir.
How
I
could?
reached out with the tray in his hand and threw it down the hallway.
Oh, okay. So it wasn't the trajectory of the tray wasn't, say, from inside the cell towards outside perpendicular.
Picture at a 90-degree angle. The offender, the slot's big enough to reach out. Under took the tray, went like this, and then the rest of the trays went out after that.
Okay. Now, if the rest of the trays went out, what were the trays that he was able to hit you with after that?
There were 4 offenders in that cell. All the trays, when they're finished, they're set on the ground. The offender took all the trays from the rest of the offenders once they were done with them and utilized those.
Okay, so those were not the same trays then. Those weren't his trays. Okay. When you entered the cell, did Mr. Moyer make any indications as to his inability to place himself on his knees?
No.
He didn't make any indication regarding having medical issues?
Mr. Moyer stated that he had, I can't remember exactly what he had stated. He stated that you're not allowed to tase me, you're not allowed to tase me, something to that effect, which I explained to him, if you comply, that won't happen, to which he said he wasn't going to comply.
But he didn't make any indication that he had a medical issue that prevented him from dropping to his knees?
No.
What type of medication was Mr. Moyer to be taking?
I am not 100% sure. There are, on average, 85 offenders in the jail. I would say a good portion of them, 25% plus, take medications. I couldn't be able to tell you what each offender takes.
Has Mr. Moyer ever indicated that he's not able to get certain of his medications to you?
Not to my knowledge.
Okay.
that I am able to get on my knees.
No further questions.
Can you redirect?
No,
Proofs?
no, Your Honor.
Any defense proofs?
None, Your Honor.
Argument?
Just briefly, Your Honor, on or about, well, Corporal View testified that on or about December 11th of 2023, he was working in the jail in Sheboygan County. He was doing a round in the jail for dinner and doing medication rounds. He got to the defendant's cell. It sounds like he asked the defendant to take his medications with water. The defendant refused. Sounds, well, by way of the testimony, there was multiple assaults that occurred in the jail on Corporal's View. There was a tray thrown at him. There was water thrown at him. A cup thrown at him. Those are all assaults. The defendant was lawfully confined in the jail, and Corporal View was lawfully performing his duties. I would ask the court to find over on count one.
Thank you, Mr. Wirgo.
Your Honor, defense argues that the nature of the contact here, it does not rise to the level of harmful or offensive as would be required to satisfy an assault, and therefore we would ask that the matter not be bound over.
All right, I'm going to find that there is probable cause to believe that the defendant did commit the offense contained alleged in the complaint. He's lawfully imprisoned in the Sheboygan County Jail serving a sentence out of the circuit court. And Corporal View is an employee of the jail as a corrections corporal. In the performance of his duties, he's providing medication to Mr. Moyer. Mr. Moyer is not complying with the rules and regulations for how to do that and becomes agitated. And he throws objects at Mr. View, striking him with at least one or more of those objects. That does constitute the elements of an assault, and Mr. Moyer being an inmate to Mr. View being an employee of that does constitute the crime of assault of a prison employee, the felony. So we'll bind over Mr. Moyer to the circuit court for arraignment on those charges. On that charge on April 9th at 10 a.m. will be the arraignment date. Anything further?
No, thank you.
Okay. All right. Okay. Yep.
All right, and Mr. You know what, let's we're going to take a quick sentencing on People v. Card with Mr. Kukuski.
Morning, Your Honor. Luke Gusky on behalf of Vander Card.
This is file 22-0325SD. You had a chance to review the
We have, Your Honor.
additions, corrections.
There were no additions, no corrections to that report, Your Honor. Allocution, Your Honor, Ms. Card, back when this offense occurred back in 2022, was not a good place in her life, and obviously had some issues there. She's taking responsibility for those issues. She's actually, since this offense, engaged herself in some counseling and some treatment. I do see that the recommendation was for a mental health assessment. I think she has underwent that. I think she's now in a better place and is currently counseling. She did do a assessment with Harbor Hall, and she's following the recommendations of that assessment with the Harbor Hall agency, and going to do some counseling with them as well. I'd ask the court to follow the recommendation that's outlined here in the report. She hasn't had any issues since the offense. I'm not sure why or what happened to make it take so long through the court system, but here we are. So I'd ask the court to just adopt the recommendations.
All right, thank you. Ms. Card, you don't have to say anything, but you're allowed to. Is there anything you want to tell me? No.
I just want to say I greatly am sorry for everything that I've caused and looking forward to a better way.
Ms. Miller, recommendations from the people.
Yes, Your Honor, Ms. Card is 48 years old. I don't see any criminal history for her on the date of this offense. She was found sitting in the driver's seat by law enforcement. She reported that she'd been driving around all night and that she stated she'd blacked out. The law enforcement observed some extensive damage to her vehicle. Both mirrors on the car appeared to be smashed and there's damage to the fenders of the vehicle. Due to the condition that they found her in, the condition that her vehicle was in, and the fact that she stated she was blacked out, Ms. Card is extremely lucky that she didn't injure anyone or herself in that condition. Her blood alcohol content at the time of the offense was a 0.223. I would note that this offense did occur back in 2022. Since then, there hasn't been anything else. I would ask the court to order the OWI reimbursement of $81.42 to Tuscarora Township. I do think that the recommendations are appropriate, that she continue the mental health treatment and counseling with Harbor Hall, and continue the conditions regarding no alcohol and the testing. I think it was a significant event, but I think that with her no criminal history and the services that she's engaged in at this point, I think the recommendations are appropriate. Thank you.
Thank you. I was wondering too, well, how come it took so long? But it took so long because Ms. Card didn't appear. So there was a warrant for.
Okay.
All right. Well, Ms. Card, I mean, given the damage to your car, the high BAC, the failing to appear, if we just looked at that alone, we'd be saying, boy, all those indicators are pointing toward you getting some jail today and not a little bit. But there's some mitigating factors here in that, I mean, you called the police on yourself. You knew you were in a bad spot and you made a series of bad decisions and then you made a good one. And that has some negative consequences in your life, but you made it nonetheless. So that's good. And you are engaged with counseling. You're in a better, a healthier spot today. So that's what we all hope to see. So those are the reasons that despite those aggravating factors, you're not going to go to jail. I am going to place you on probation as recommended for 4 months with Agent Wergo. I'm not going to order you complete a mental health assessment, but that you continue the outpatient counseling as recommended by Harbor. You can't use or possess alcohol or controlled substances or be in possession of others using them. No mind altering substances. You have to submit to pass a PBT and drug test on request of the court. You can't be in any establishment where the primary purpose of the business is serving alcohol. You can't utilize medical marijuana unless you notify the court and present medical proof from a physician that's medically necessary for you. I'm going to order that you serve 2 days jail, give you credit for 2 days served. Order that you complete 2 days on the sheriff's work group program. There's some fines and costs: $50 fee to the state, $75 crime victims assessment, $200 court costs, $81.42 for OWI reimbursement, $175 penal fine, and $120 in oversight fees for a grand total of $701.42. This is a departure from the statutory presumption of no probation due to the high BAC and the aggravating factors that I had outlined earlier. Ms. Card, good luck to you. If you wanted to appeal, you have to file an application to the circuit court within 21 days. If you wanted an appointed lawyer, you're going to ask within 14. So stick around. The court will have some stuff you fill out and maybe talk to the commission officer.
Very good, Your Honor. Thank you, Your Honor.
Okay, let's call People v. Marissa Johnson, file 24-119 FY.
Anthony, you read on behalf.
here for examination. All right, and how are we proceeding on this?
Your Honor, Ms. Johnson does wants to conduct a preliminary examination.
Any opening remarks from people?
No, thank you.
Opening remarks from the defense?
None.
Deputy Duchowski.
Or tell the truth, the whole truth, and nothing but the truth, so help God. I do.
Deputy, can you state your full name and spell your last name?
David Duchowski, Duckowski.
And where do you work?
Sheboygan County Sheriff's Department,
How long have you worked there?
just over 3 years.
Were you working on February 20th of 2024?
I was,
You accurately recall your shift that day?
I can,
Did you have contact with the defendant that day?
I did.
Okay. What caused you to have contact with her?
We had a vehicle that we attempted to stop. The vehicle did not stop, so we ended up in a pursuit. The vehicle ended up crashing and the defendant was a passenger in that vehicle.
Okay. Is the defendant present in the courtroom today?
Yes,
What color shirt is she wearing?
she's wearing a gray zip up.
Thank you. Your Honor, can the record reflect Deputy Duchowski's identified the defendant? Thank you. So what happened after you made contact with her?
After we made contact with her, the original contact, my partner talked to her, and she indicated that she had been a passenger.
Objection as to the foundation of this knowledge. It sounds as though he's testifying as to information that he didn't hear from Ms. Johnson herself.
I mean, maybe lay a foundation about
Yeah.
whether she said that to you or heard it.
So were you present when she was making these statements, or did you hear it through somebody else?
For the initial contact, after the initial contact, that was my partner. I was not part of that one. She then went to the hospital and then I had contact with her after that.
Okay, so your contact with her wasn't at the accident?
Correct.
Okay.
Very, very brief at the accident.
Okay. So can you just briefly describe the accident, what it was?
The vehicle was heading west on Orchard Beach Road. They crossed M33 at a high rate of speed, went airborne, lost control, crashed, ended up on its side. We got the driver out. I was dealing with the driver of the vehicle while my partner handled the passenger.
Okay. Did the defendant go to the hospital or anything?
She did.
Okay,
After the crash, EMS wanted them both sent to the hospital. They both agreed to go.
okay.
A pretty violent crash.
Did you do any investigation into the vehicle?
We did. After we had both the driver and the passenger, they were the only two occupants of the vehicle. They both had to go to the hospital. So we did. We got the vehicle impounded then at that point, and we did an inventory of the vehicle. And then during the inventory of the vehicle,
I would object as to the inventory foundation issue. I don't know if the officer's testifying his own personal knowledge or knowledge of other officers.
Okay, well, I mean, you did say we did an inventory, so I guess Deputy Duchowski, I'll just remind you for you to testify only to your observations and what's in your direct knowledge. So to the extent you can, if you can say that you did something, if you say we did something, indicate who the we is. So go ahead and ask that question.
Did you do any part of the inventory search?
I did. I took all the photographs for the search.
Okay. Was there anything concerning that you found in the vehicle?
So I was taking the photographs. I did a 360 of the vehicle. And then as we were going through the vehicle, when people would find something of, when other officers would find something of value or of concern, I would take the photos of it.
Okay, did you take any photos of anything concerning?
I did. Inside the, we found a.
Who's we? Who's we?
Sorry, I found it was, officer, the other officer was one from Alpena. It's in my report. I don't remember which officer was that found it. I took the photographs of it.
What is it?
It was a small, little silicone container, about 1.5 inches around, and inside there was a white residue. And then the white residue was field tested and tested positive for methamphetamine.
Okay, where did you find this this?
It was in the back, kind of like it was an SUV, so it's kind of like the back cargo area of the SUV.
Okay, did you find anything else of significance?
Yep.
In or around the methamphetamine?
So after we found that one, then we also found Sergeant Heckel found a bag that I photographed. It was a pink bag, and inside the pink bag was the defendant's wallet and had her ID and credit cards, those types of things. And then also had in the front pocket was a small mirror and also a tutor. So it was about, can't recall exactly, maybe about 3 inches long, blue tutor with white residue on the inside that also field tested positive for methamphetamine.
Okay. At any point during this investigation, did you have contact personally with the defendant?
I did.
When was that?
That was after she got released from the jail. We arrested her on probable cause for having the methamphetamine in her bag. And then I took her to the jail and we booked and lodged her. I read her Miranda rights and interviewed her in the jail.
Did she acknowledge the methamphetamine or anything like that?
She acknowledged that it was her bag and that it was a bag she carried daily. She denied the methamphetamine being hers.
Okay. And I just want to be clear as to this container. Did you find it in her bag or was
the blue silicone container was not in her bag? The mirror and the tutor with the methamphetamine residue, which I also true narked once I got back to the sheriff's department, that did test positive for methamphetamine. Those were in her bag. So the blue silicone container was not. The mirror and tutor were in her bag. The mirror also had a residue on it. We didn't test it.
Okay. Was her bag open or closed?
It was closed.
Okay. This happened in Sheboygan County?
Did.
I have no other question.
Cross exam.
Deputy, is it Dushkowski?
Dushkowski.
Dushkowski. I'm sorry, I have Polish heritage. I try and get them right.
That's always tough.
Then Ms. Johnson was a passenger in the vehicle?
She was.
Okay, and were you able to observe part of the driving prior to that?
I was.
Okay, and then is there any doubt in your mind that she was not the driver?
No.
Okay. Now you had indicated that you field tested some of these items. What sort of field test was performed on these items?
It was, I have the name of the field test in my report. I can't recall exactly what it was, but it's one that you put, and the hunt team actually was the ones who field tested it. And then I did the true narc when I got back to the sheriff's department.
Okay, and then so the test that you performed yourself is the true narc?
Correct.
Tell me a bit about that test. How does it work?
It's basically what you do is you take, it's a small machine and you put it shoots out a laser and it does an analysis. I don't know the exact how it does all the analysis. I know that it does an analysis on it and it'll test and it'll tell you what kind of substance it is.
So you yourself aren't familiar with the inner workings of the machine and how it performs the test?
Not any more than that it's a laser and it does a chemical analysis of it.
Fair enough. Now you stated that the mirror and the tutor were in Ms. Johnson's bag. How did you identify that the bag was hers?
Inside was her wallet that had her ID and credit cards and personal items like that.
Were there any items that were in the bag that were not hers or identifiable to her?
I don't recall. I don't believe so, but I couldn't say for sure. I don't recall. I have photographs of it, but I don't have them in front of me.
Fair enough. And the tutor was tested, correct?
Correct,
But not the mirror, correct?
correct. There wasn't enough residue on the mirror to true narc.
I have no further questions for the deputy.
All right, any redirect?
Just one question. When the police officer from the hunt team did the field test, were you
Yes.
present for
I
that?
was.
Okay. I have no other questions.
Any further cross on those points?
None, Your Honor.
Okay, you step down there. Proofs,
No, Your Honor.
any defense proofs,
No proofs, Your Honor.
argument?
Deputy Duskowski testified that on or about February 20th of this year, he was involved in a police chase in which the defendant was a passenger in a vehicle that ended up in a crash. He testified that he did inventory the vehicle. While inventorying the vehicle, he located a bag that contained a number of what appears to be items belonging to the defendant, her cards, her license. Also in the bag, or in close proximity to the bag, was a silicone container that field tested and later subsequently true narc positive for methamphetamine. He also testified that he found a tutor in her bag, and that did test positive on the true narc machine for methamphetamine. I think there is at least circumstantial evidence of constructive possession, if not direct possession. I've asked the court to bind over on count one.
Thank you. Defense?
Your Honor, the defense at this stage would ask the courts to not bind over based upon the true narc test, not having any foundation that would fail Daubert. I'm unaware, at least, of any case law that automatically would make the true narc test viable scientific evidence of the kind the court could just take judicial notice of, such as field sobriety tests or anything like that. That's our argument, Your Honor.
All right, well, I'm going to bind over Ms. Johnson to the circuit court for arraignment on the charge of possession of methamphetamine contained in the complaint. For arraignment date will be April 9th at 10 a.m. There's evidence that after the crash, the officers, after impounding the vehicle and doing an inventory, find some suspected methamphetamine and including a pink bag. With inside that bag are indicia that it belongs to the defendant, her wallet, ID, credit cards. And it's not just that there's some random something white that they do this test where we need to get into the science too much of the test. There's a small mirror and a tutor, and they see residue, even if they didn't true narc it. That's some pretty good circumstantial evidence of drug possession right there as well. So that on top of the true narc test, it's pretty clear that this is not baking powder or sugar or anything like that. People won't snort those things. So they field test it and it's positive for methamphetamine. That's consistent with the officer's suspicions and observations. And kind of probable cause standard, there's sufficient evidence to bind over in that charge. So I gave the circuit court arraignment April 9th at 10 a.m. I will note, we're not here to arraign on all of these, but man, I'm looking at the file. There's not one, not two, but three pending bond violation show causes coming up where she's got dates on the 21st of March and on the 11th of April. Missed calls, missed test, dilute test, at least one positive test. It looks like maybe more than one for methamphetamine. So I'm not gonna go through the arraignment on all of those, but I've got sufficient reasonable grounds to be concerned about the conditions of bond. I want to hear argument from counsel about whether bond should be revoked.
Your Honor, this is a possession of methamphetamine case. If she is testing positive, not once, but more than once for the substance that she is in court for, I would ask that bond be revoked. I mean, this is a 10-year felony and she's out on bond. With the missed test and the positive test and the missed calls, it's clear she's not complying with the court's order. I'd ask that bond be revoked.
Mr. Burgo?
Your Honor, I do know that Ms. Johnson is testing in Alpena. And there's a bit of an overlap on that. As to the actual underlying factual nature of the allegations, I can't speak to them. I haven't seen them, but Ms. Johnson has shown up for every single court appearance. She's here today. She wants to deal with this. And Your Honor, I think that it would be premature to revoke her bond at this time without having an opportunity to actually have the matter heard and evidence presented in the proper fashion.
All right, well, I mean, it's not her appearance that is a concern, but her compliance with conditions for her safety and the safety of the public. There's enough violations going on. She'll get her arraignments and her hearings on all of those, but I think I've got sufficient grounds at this point to be concerned. I'm going to revoke Ms. Johnson's bond and remand her to custody sheriff.
If I may, Your Honor, Ms. Johnson has indicated that she's been working with Harbor Hall to try and secure inpatient rehabilitation. We would ask that she be allowed to continue that, and if she is successful in getting a bed, that she be allowed to transfer to Harbor Hall.
Well, I don't know. I mean, she's also on probation over in Alpena, so I think there's some moving pieces to coordinate. So if something like that is going on, I think you probably need to talk to the prosecutor's office and double check with Alpena probation and see what they want. All right, Ms. Johnson, you'll appear in custody. All right, let's call people be Lohovitz for sentencing. File 24-036 SM. Mr. Burko, did you have a chance to review the pre-sentence report?
Yes, we did have a chance to review that and discuss it, Your Honor.
Any allocution?
Your Honor, Ms. Lohovitz just asks that the court follow the recommendations.
Ms. Lohovitz, is there anything you want to say?
Yes, this was not obviously a very bad choice of my own. Was driven by a lot of harbored resentments toward my ex, and I handled it in all the wrong ways, and I just want to take responsibility and get it behind me.
All right, thank you. Ms. Miller, recommendations from the people.
Thank you, Ms. Lovitz is 41 years old. I do see some criminal history for her. This appears to be the first malicious destruction of property conviction for her. What event occurred is that she carved the letters of Chomo into the side of Mr. Barrison's truck. I'd ask that restitution be ordered for the damage that was done to the vehicle in the amount of $748.94. But I do think the recommendation for the days on the work crew, the 10 days, is appropriate. Thank you.
Thank you, Ms. Lohovitz, for the full sentence. All right, well, there's some financial assessments, $50 fee to the state, $75 crime victims fund, $748.98 in victim restitution. Given that I want you to focus on the restitution, and I know from experience with you upstairs that you've got child support holes that you're in as well. I'm gonna do what I can to not dig the hole deeper for you. I'm not going to assess the court costs, and I'm not going to assess the fine. So that ends up being a grand total of, with the restitution included, $873.98. You had to set up payment plans with the district court or be subject to show causes for contempt. Here's my question for you though, Ms. Lohovitz. You don't have a great track record of complying with things I ask you to do. So my question for you is, if I order you to do 10 days on the sheriff's work crew and give you 90 days to do it, why should I think that you will do that?
I've turned a new leaf, and I know that the last time I stood in front of you upstairs, I had to take responsibility for lacking my responsibility and take responsibilities for it because of my family situation, and being in therapy and getting those things behind me has made a huge difference.
All right. So I am going to order that you do 10 days of community service with the sheriff's department work crew as recommended. I'm not going to place you on probation because that would be like extra oversight fees and extra hassles for you, and I don't think that's necessary. But I am going to give you a 90-day period to get those 10 days done. You have to provide proof to the court that you've done that. They can get you information how you can sign up for that. I can tell you, I mean, if you don't do that within 90 days, then you'll be subject to contempt. So don't do that. Okay, get it done. All right, that's the sense of the court. If you want to appeal, you have to file an application to the circuit court. If you want a lawyer, you have to ask us within 14 days. Or you got to file the appeal within 21. If you want a lawyer, you got to ask within 14. Okay, good luck to you.
Thank you.
We have a sentencing in Sheldon. Kind of deferral on that. All right, and then we have sentencing versus Heidi Ellenbach.
She's here, Your Honor. Assuming she'll be right back. Your Honor, can we jump to Mr. Laskowski? There's a delay.
Leon Laskowski. All right, that's file 23-113 SM. Looks like it's been a successful delay. The agreement calls for what at the end of that?
It was a dismissal, Your Honor, and I did receive notice from the probation department that he completed all the terms of his delay, so I do have a nollie to dismiss the case prepared. I'm handing to your bail.
Anything further you wish to say, Mr. Gilbert?
No.
Mr. Wiskowski? All right, well, you've successfully completed the terms of the delay, and we're happy to see that. And so you're entitled to the benefit of it, and the prosecutor submitted a dismissal, which I am signing at this point. So the case is dismissed, sir. Good luck.
I believe the gentleman's went out to get Miss Ellenbach, but Mr. Jennings is out in the hallway, Your Honor.
Okay. Bear with me. And this is Mr. Jennings.
It is, Your Honor. And I believe we're here on a failure to appear and also a financial show cause. Failure to pay.
All right, and how are we proceeding then?
He's going to admit to his failure to show, I believe in September, and also failure to finish up. This is a 2012 case with the remaining $550 fees.
All right. Where do you live, Mr. Jennings?
I'm living right now with in my deceased father's house, my niece.
In what county?
Aranet.
Aranet County, so not up in Alger.
Yeah, it's Alger, but it's in Aranet. Yeah, yeah,
There's a town Alger that's not in Alger County.
correct, yeah.
Well, that's confusing.
Yeah, I've heard that quite a bit, because I know there's a prison up there and.
And it's on Newberry Street. How about that? Newberry Street in Alger. And that is not the UP. How about that? All right. All right, Mr. Jennings, you understand you have the right to have a hearing where the contempt will be proven beyond reasonable doubt, and I could jail you for up to 93 days or fine you for up to $7,500.
Yes,
Has anybody promised you anything in exchange for admission to contempt for failing to appear?
no, Your Honor.
Threatened you? Is that your own free choice? Is that your own free choice? then?
No, yes, yes.
All right, so did you know that you had a court date to appear to deal with these matters?
On,
I guess let me ask a different question. Did you change your address and not tell us? Well, it looks like that. So why don't you tell me why you think you're in contempt of court for not appearing?
on the 23rd of September.
September
Yeah,
I
September 5th.
did, I was not living at that residence and I was not notified. I did not get the letter.
Okay, so you weren't living at that address and you then failed to contact the court and tell us you weren't living there at that.
Correct.
All right. So the most we can do is notify you at the place that you tell us to notify. Did you agree?
Yes.
All right, I'm gonna find that that's a sufficient basis to find you in contempt. Are you working right now?
No.
How much is owed right now?
I believe it's on here, it's 576. However, I did have Mr. Jennings fill out paperwork for some sort of payment schedule. And I believe he put another $20 down this morning.
Okay. All right. All right, this is an old 2012 disorderly matter. What I'm going to do is we're going to issue a judgment of contempt. And the sanction is just a warning to make sure that you let us know of the addresses where we can notify you of things. So there'll be a judgment of contempt. It'll track in the file. I'm not going to assess any additional fines or any other penalty. And I will direct you though, before you leave, make sure that you fully filled out whatever the court needs for you to set up a payment plan so that you can take care of this over time. Okay.
Okay.
Good luck to you, sir.
Thank you very much.
Right, so people be Hellebuyck.
Yes, very well.
All right, and this is file 20741 SD. Mr. Gilbert, have you had a chance to review the report and recommendations?
Oh, we did, Your Honor.
Okay, any additions, corrections?
They're not.
Anything you want to say in your client's behalf?
Oh, Your Honor, my client has set up her intake for the evaluation, it just hasn't been completed yet. And we're in support of the recommendation. However, we'd ask versus the work crew, my client lives in Grayling, if that could be community service instead. Thank you.
Great, thank you. Ms. Hellebuyck, you don't have to say anything, but you're allowed to. Is there anything you want to tell me or no?
I'm obviously very sorry, and I completely agree with everything. Yes.
Ms. Miller, any recommendations from you?
Yes, Your Honor, Ms. Hellebuyck is 41 years old. I do see criminal history. I did see there was a conviction out of Crawford County 2009 for an impaired driving that wasn't shown on the prior record of the PSI. So I would just ask the court to consider that. This was a pretty significant incident. Ms. Hellebuyck was operating her vehicle. She hit a street sign reflector. There was a piece of her car that was lying on the side of the road. When there was contact with the police, she was slurred and confused. She was unaware that her vehicle had hit anything. The officers did note that there were 15 cans of electronics duster in her vehicle, including one in the passenger seat next to her that had been used, that had been opened and used. Ms. Hellebuyck also had a small amount of the difluoroethane in her blood, which is indicative of the huffing of the electronics duster. So I think it is a pretty significant offense. I do think that probation is important for this case, that she follow the recommendations of the assessment, that the OWI reimbursement be ordered in the amount of $225, that the conditions regarding the possession of alcohol and intoxicating substances are in effect, and that the 27 days of jail are held in abeyance for in the event that there's any kind of violation. I do note that she does not live local, so I don't have an objection to the work crew days being some kind of community service instead. Thank you.
All right, well, I'm not gonna do any abeyance days. I just don't, I don't even know how those. And I know different judges think differently about that. I don't think that's a real appropriate way to go forward, because we can't impose days in abeyance without following the due process requirements and the statutes on probation violations anyway, which would be true whether we have days in abeyance or not. So I don't think they accomplish it. So I'm not gonna do that. Ms. Hellebuyck, there's some financial assessments, $50 fee to the state, $75 crime victims assessment, $200 in court costs, $225 OWI reimbursement, $175 penal fine, $180 oversight fee. That's a grand total of $905. I am going to place you on probation for 6 months with Officer Wergo. During that, you have to complete an assessment and follow the recommendations. You can't use alcohol or controlled substances or be in the presence of others using illegal controlled substances. Notify the court of a medical marijuana card and provide proof at a hearing that's medically necessary. No mind altering substances to pass PDT and drug testing. Here's the thing though, I mean, there's a lot of aggravating factors here. There is a 2009 impaired driving that shows up not on the CCH, but that's not always super reliable. It does show up on your driving record. The time of day here, you're driving at a time when there's a whole bunch of people on the road. You're huffing, you got all that stuff in the car. You're going off the road into a ditch, and then you're leaving the scene, continuing to drive. There's evidence in the car of drug abuse with the prior as well. Those are significant aggravating factors and a significant risk to public safety. So that's a reason to depart from the statutory presumption for no probation, no jail. I am going to order that you serve 10 days in the Sheboygan County Jail, credit for 3 criminals served.
Can I, and I know that when you asked me earlier if I had anything to say, it kind of sounded like, I explained this to the lawyer and I know it may not, but I had started a different end, and if I'm like emotionally, like not explaining any of this right. They started me on antidepressant. I've been trying to get it for 4 days after I just started working, so I'm a little wonky right now. But yes, I was stopped when they pulled me over and stuff because it scared me what happened. And outside of what this sounds like, I am a really good mom, and I get proof of that from strangers telling me about my kids and stuff when they first meet them, and otherwise I wouldn't say anything. And I know my lawyer's probably saying I'm dragging on right
That's
now,
fine.
but I just,
I'm not saying you're a bad person. This crime in a sentence doesn't make you a bad person.
I'm just,
So that's the
I'm
sentence of the court.
ready to take advantage of this probation time to have a better report at the end of it.
All right, ma'am, you can appeal to the circuit court within 21 days if you wish. You can ask for a lawyer within 14. If you want to appeal, you have to file it within 21. If you want a lawyer, you have to do within 14. You are going to jail.
I have a lot of issues medically though, sir.
The
That
jail will
is,
take care of those for you.
oh, we weren't even,
Heidi,
We need to come right now.
do you need your purse?
hey, I'm not trying to say I'm not gonna go, but oh, please, sir, can I have one day? My kids don't know anything like my
Do you want your purse or no?
cats.
Purse or
You can't let this happen.
I don't.
All right, are you Tyler Person?
Yes, sir.
Want to take your hood off?
Yes, sir. I can do that.
This is file 24-176FY for arraignment. And Mr. Varga, you're the arraignment attorney. Did you get a chance to meet with Mr. Person?
Yes, I have, Your Honor. Good morning. For the record, Ronald Varga, on behalf of Tyler Person for this arraignment. Prior to this case being called by the court, I did have an opportunity to meet with Mr. Person in the Sheboygan County Jail. At that time, I provided him with a copy of the information that's been found in this matter. Went over that information with him, advised him what the charges are as well as potential penalties. Indicated to me an understanding of both the charges and penalties, and given that understanding of the way the form reading the charges of the record. We then moved to the advice rights form. I provided him a copy of that advice rights form and went over that form with him. He understood the terms of that form and understood the guarantees that were offered or set forth in that form. And to that, he signed that form on his own behalf. I have it here presented to the court. We're ready for the arraignment.
All right, thank you. All right, well, Mr. Person, I see you've signed your felony advice of rights. You do have the right to an attorney and a right to a preliminary examination within 21 days. I won't read the formal allegations, but advise you of their maximums. Count 1 alleges criminal sexual conduct in the first degree, punishable by life or any term of years, discretionary consecutive sentencing, mandatory lifetime electronic monitoring, mandatory AIDS and STD testing. Count 2 is criminal sexual conduct in the first degree. Oh, and that's a registration offense under the Sex Offender Registration Act, Tier 3 or lifetime registration. Count 2 alleges the same, and count 3 and 4. So it's 4 counts of the same offense with the maximum penalties of life or any terms a year with lifetime electronic monitoring and lifetime registration. And Mr. Varga, is he seeking court-appointed counsel?
Yes, he is, Your Honor. He is eligible, and this case will be assigned to Mr. Gilbert.
Okay, so we'll refer it to the Office of Assigned Counsel for appointment of Mr. Gilbert. We'll schedule it for a probable cause conference on April 4th at 10:30 a.m. and preliminary examination on April 5th at 10:30 a.m. As to pretrial release, Mr. Varga?
Yes, Your Honor, we're seeking bond in this matter. Mr. Person is 20 years of age. He is a lifetime resident of the Cadillac area. He was living up here with the alleged victim in this matter for a period of 9 months, I'm sorry. He is employed. He is in the construction industry. His latest employment, he's not employed at this point in time, but his latest employment was builder construction, modeling. And then a seasonal employment. He currently lives with his mother in the Cadillac area. He has no criminal history at all. He has no once or warrant. I believe a reasonable bond would ensure his future appearances in court. Your Honor, it's not a threat to society in general, and the court can ensure the safety of the alleged victim with no contact provision.
All right, thank you. Ms. Goodrich?
Your Honor, this is a CSE first charges, so I would ask the court to deny bond pursuant to MCR 6.106B due to the nature of the charges. These charges happened on 2 separate nights. There were multiple penetrations involved. It was a vulnerable victim and occurred while she was sleeping. The defendant has made admissions in the affidavit, and it's my understanding he was aware that the victim reported and previously was living with her, but was found in Cadillac at his mom's house. If the court does award bond, then I would ask the court to consider the probability of conviction, and again, defendant's admissions, and order no contact with the victim, Destiny Johnson, no entry into the premises at 9269 Charles Street in Onaway, that he not be allowed to use or possess any weapons, and not engage in aggressive or assaultive behavior. Thank you.
Just want to double check the. Do you wish to be heard on any application of the courtroom, Mr. Varga?
Your Honor, as I recall the court, it says bond may be set in this matter. It's not absolutely precluded.
All right. Based on my review of the affidavit, with the more than one incident date and the admissions that the defendant made and the charge of CSC first degree with the life penalty. Yes, I would grant the prosecutor's request to deny pretrial release to Mr. Person until further word.
Thank you.
Thank you.
Yeah, but there is a no contact with the victim. That's going to be an order of the court, even though there's no bond. All right, you're all set, Mr. Person.
Thank you, sir.
All right. We had a contempt on people be Michael Hoffman. Was that Mr. know if he's got, okay. Yeah, maybe, I don't know if he's on the case or what the consent is. Oh, it's a money one, so, I don't know. Is he here?
See you later on today, Judge.
All right, so we're back on the record and we have two more matters on what was our morning docket, but we're in the afternoon. My apologies. 21-919 FY, people be Michael Huffman, and 21-967, people be James Harshman. Mr. Gilbert, you're here on behalf of both of those gentlemen.
I am, Your Honor, and I did make attempts to contact them yesterday and I was not successful.
Okay, and these are contempt hearings for failing to appear and failing to appear. They're not here today. So Ms. Miller, any objection to a warrant?
No, Your Honor.
We will issue a warrant. I think they both owe significant sums, but so that bond could possibly be posted. I'll go ahead and set a $1,500 bond on both matters.
Thank you very much, Your Honor.
Thank you.
All right, so that'll conclude our docket.